According to the Daily Beast, Trump's legal team suing the writer Jean Carroll regarding the sexual assault he claims to have committed against him in the 1990s has decided on a new course of action, agreed to DNA testing of the president the first floor, that is, something Carroll had previously advocated. Carroll still has the same clothes he says he wore in the first attack, although he and his lawyers have recently turned to other areas of interest, such as the installation of the president first and the debate from this meeting, which took place at the end of last year. At this point, it is unclear whether the test will actually be completed. The Daily Beast says that the timing of Trump's plea agreement, along with several investigative processes already underway in the upcoming trial next month, could shape the former president's decision to plead guilty to a grand jury. Because that would lead his lawyers arguing that he gave his DNA for an unprecedented test. Probably, Carroll's lawyers can argue at the same time that Trump is still running away from him because he can turn to this offer exactly after the many investigations. In civil cases like these, there is a greater chance of conviction than in a normal criminal case. The pretrial discovery process allows the two parties to gather important evidence, and at this time, both sides are still facing a medical examination of Carroll, apparently by a mental health professional, but which that seems to be about it, at least as it is. To the extent that the author's comments cover up the events that he claims to have happened in the first place. His first defamation charge was a response to the opposition's response to his first article about Trump when he was still eligible for a hearing. Now he has yet another defamation lawsuit against Trump regarding a statement he made on his fake social media site Truth Social, where he defamed him again, this time long after he left office. This time it means that the debate elsewhere in the court about whether there is legal protection for his earlier statements about his role as president is not necessary. Trump did this himself, ensuring that at least some of the defamation charges could stand regardless of how other disputes were going. A trial on at least one sexual assault and defamation charge will begin on April 25, according to the current schedule. Federal Judge Lewis Kaplan, who is in charge of the case, often opposes the idea of delay, so it is not clear that the process is necessary. Opening and extending other parts of the investigative process for DNA testing will be done.